I want to highlight 4 issues that I think will be important. The definition of terrorist activity, which the Irish Human Rights Council has described as so impermissibly wide that it risks describing groups opposing dictatorial or oppressive regimes, anti-globalisation groups, anti-war or environmental protesters, or even militant trade unionists as terrorists. That definition needs to be functional and it needs to be looked at very carefully so that we do not in any way stifle civil society activism, which I know is something Ireland has always seemed to support. The operation of the Special Criminal Court should only be allowed in situations where our ordinary courts are shown to be unable to adequately administer justice. The burden of proof is on the government to actively demonstrate that there are no effective alternatives to non-jury trials. Are there, for example, other measures which might be taken to protect juries in sensitive cases? Thirdly, compliance with UN law and recommendations, particularly in the context of Ireland taking a seat at the UN Security Council. The UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism has specifically criticised Ireland's Special Criminal Court, noting that the seepage of the exceptional into the ordinary in ways that have not served the rule of law nor the protection of human rights well. At a time when we are seeing a worrying new wave of authoritarianism across the globe, along with attempts to undermine and attack rule of law, we need to think very seriously about what message we are sending and what tacit signal we might send through our own policies and practices. Faith in the rule of law and the fair operation of the law is one of our greatest defences against radicalisation and in terms of the underpinning of democracy. Lastly, I would like to give clear notice of 12 months that the renewal of this Act in June 2021 should not be assumed. And as a senator and a legislator, I will be basing my scrutiny and decisions at that time on the outcomes of the review on human rights law and on legislative rather than operational considerations.